In 2019, the North Carolina Department of Health and Human Services awarded multi-billion-dollar Medicaid managed care contracts to 4 private companies. These companies scored highest on an evaluation. But now there are questions about whether the agency actually put its thumb on the scale in favor of one company and against another. This whole question is the subject of a really interesting piece written by my next guest. He is Dr. Don Vaart. He is Senior Fellow with the John Locke Foundation. You can read this piece at johnlocke.org. Don, welcome back to the show.
Thanks for having me.
So what you've written about apparently is serious enough that this has ended up in court. Tell us who is suing whom.
Well, so Aetna Insurance Company bid for some of these contracts and lost. And they, for various reasons, believed that the process was in some way arbitrary and capricious and filed suit against DHHS for review. And so now they're, as the Administrative Procedure Act requires, they are in the Office of Administrative Hearings right now.
These contracts, Don, just briefly explain what they are and why it is either lucrative enough or influential enough to have one that someone would actually sue over not getting one.
Well, very briefly, for many, many, many years, North Carolina was one of the last remaining states to implement Medicaid through a fee-for-service model. Most other states by far had gone over to a managed care model, which we're pretty much all familiar with. And so in 2015, actually Donna Martinez under the McCrory administration pushed to get this moved over to a managed care model. There are two things that are important. One is that the amount of the contracts are large, very large. This is the largest set of contracts that the state has ever let to private companies, $30 billion over 5 years. But number two, they probably are very lucrative because the companies realize that they are starting as a baseline with the historical fee-for-service expenditures of the past years. They believe through their experience that they're going to be able to save a significant amount of money under the managed care model. And it's this difference that they're going to be able to keep, or at least part of, as profit. So it is extremely lucrative, probably. And these insurance companies are looking at a contract, since they were going to award 4, they were looking at a contract of around $6 billion over 5 years.
Wow, so that's a huge business opportunity. And for Aetna, which was not selected as one of the 4, that is a big loss to the company.
Loss. Very much.
So tell us how these 4 firms were selected. We were told that this was an independent evaluation and that each of the companies were scored essentially on certain parameters, and that Aetna simply didn't make the top 4.
Right. So DHHS developed an evaluation team, and there were some 7 members, and they were made up of DHHS individuals, but they all had expertise in this area. They met many times to evaluate the proposals from a number of, I think 7 or 8 different companies. And they scored them along a long range of criteria, and that's how they were going to develop the winners. The top 4 were going to be winners.
Now, is it fair to say that Aetna thought that they were going to be the 4th firm selected, but in the end, it ended up that they were scored as number 5, and a different firm became number 4 and therefore got a contract?
Actually, the results came out and Aetna lost for a number of reasons. They believed that there was perhaps some conflict of interests between some of the members at DHHS and the firm that one of the firms that ended up winning. So they filed suit.
So, Don, it's interesting because folks listening to us might say, well, I mean, sometimes you win a contract, sometimes you don't. That's just the way business goes. And, well, Aetna should just accept that and move on and try to get other business. But something came out in these proceedings over this case that was pretty unexpected and got Aetna's attention.
Well, here and here's the really bizarre thing. First of all, they filed suit based on what they believed were some conflict of interest, personnel conflicts of interest. So they filed suit. Then they began the discovery process, which is the first part of a fact-finding part of the litigation. And during discovery, nothing more was found. But they continued to have, for example, relationships between members of the DHHS team and this one firm, Blue Cross Blue Shield. So during discovery, nothing more much came out, but then they started to depose some of the DHHS employees, and that's where there was a real surprise. So during one of the depositions where these witnesses are essentially questioned under oath, it came out that at the end of the process, the review process by the evaluation committee, Aetna had actually been scored in the top 4. In other words, they were one of the winners. And that document was not revealed to Aetna during normal discovery.
Now, isn't that an ethical breach? I mean, if you watch Law and Order, you kind of know about discovery, and attorneys are required to turn over materials to the opposing side, no?
That's exactly right. And you can understand from a judicial efficiency standpoint that the court wants to get all of the facts out between the two parties. And maybe after all that's done, one party says, nah, you're right. You probably did the right thing. And so when you have the possibility of attorneys concealing information, that's one of the ethical requirements. You don't do that because you want to have both sides have all of the facts before them, before the court spends their time adjudicating. And in this case, if you're talking about if you're Aetna, put yourself in Aetna's shoes, you're Aetna, and you believe for other reasons that you were treated unfairly, okay? I think probably a very important document to you might be a earlier draft final list, really, showing that you were a winner, but then ultimately you were not. And so that list is particularly important to Aetna.
So, Don, what does the state say about this? I mean, do they must dispute that Aetna actually was scored higher than Blue Cross? Because at the bottom line here, it ends up that Blue Cross is one of the 4 firms that got the contract, and Aetna did not.
Right. So what happened then in the real process before the litigation? Apparently, there was this list developed by the evaluation team showing Aetna was one of the 4 winners, and Blue Cross Blue Shield was not. And then there was an outside senior leadership discussion, and the deputy general counsel stepped in and changed an evaluation parameter, and then Aetna lost.
So, Don, where does this go from here?
Well, right now, the state is actually fighting Aetna's right to include this document in their complaint, which is absolutely bizarre. So that's where they are right now. They're trying to convince the judge to allow them to amend their complaint to include this new information.